Morning, everybody. Thank you for logging in today to join Shan and myself for this presentation on resolving disputes in the Caribbean. But first, I'd like to thank the BVI Arbitration Centre for hosting us today and for all of their hard work over the last couple of weeks in the background to make this possible, particularly Francois, Jeanette and Chantal, to name a few. We understand that everyone is busy and that we're taking up your valuable time today, so we'll try and keep it within the allotted hour. If we find there's real interest in the topic and we don't have time to cover the questions, we can take it offline afterwards and respond directly to you by email, or even possibly put on another webinar to cover further topics as required in the future. The format for the hour will be a short introduction to the two speakers, and then I'll hand over to Shan, who will run through the main part of the presentation today. A housekeeping note is that by default, all of your microphones are muted. So during the presentation, if you do have any questions on what's covered, then please type them into the chat box and I will either field them at the time or at the end during the question and answer session before our time runs out. So to kick things off, I will introduce Shan.
Thank you, Graham, and thank you.
I'll give you an introduction, Shan. I'll tell them all about you.
Oh, sorry.
No problem. Shan Greer is an international lawyer with over 20 years experience in advising clients on a wide variety of commercial transactions and disputes with specific expertise in construction law. She's known for her practical and commercially sensitive approach to handling matters and has successfully handled commercial transactions and disputes across multiple jurisdictions in the Caribbean, Europe, and North America. She first qualified and was admitted as a barrister and solicitor in England and has a master's from King's College London in construction law and dispute resolution. She's also admitted to practice in St. Lucia, St. Vincent, and Belize. Shan has advised on numerous large infrastructure and construction projects for state-owned enterprises, international investors, joint venture partners, and regional consultants, under which the parties used bespoke, FIDIC, JCT, and NEC standard forms of contract. In addition to her work with the construction and infrastructure sector, Shan has also represented clients in matters relating to oil and gas, hotel development, gaming, banking, and finance, as well as the energy and telecommunication sectors. Shan regularly acts as an arbitrator, adjudicator, and mediator in ad hoc, institutional, and international domestic arbitrations, both in civil and commercial law jurisdictions. She's currently named to the rosters of the International Institute for Conflict Prevention and Resolution, the BVI International Arbitration Centre, Dispute Resolution Centre in Trinidad and Tobago, Dispute Resolution Association in St. Lucia, and the Jamaica International Arbitration Centre. How do I follow that? Well, I'll give it a go. So my name's Chris Graham. I'm director of BCQS International. For those who don't know, it's a property development practice providing a full range of independent consultancy services to the construction industry in the Caribbean and Latin America. I am not a lawyer, and my background is in providing project and cost management services, dispute resolution services, expert witness services, development appraisals, project feasibility studies, and claims consultancy services to a wide range of public and private sector clients, the last 17 years of which in the Caribbean region. Before that, in my previous life, I worked for Davis Langdon in London and specialized in offices and tall buildings. I worked on a range of projects from the early feasibility studies of the 72-story Shard in the city and concept design right the way through to the final handover of the 44-story HSBC Tower at Canary Wharf, and a host of other projects with renowned architects Salomon Foster and Zaha Hadid in the UK, Italy, France, and Abu Dhabi. I have a degree in economics and quantity surveying, an MBA with distinction, a diploma in arbitration. I'm a fellow of the RICS, a member of the Chartered Institute of Arbitrators, RICS Registered Valuer, and a board member of the BVI Arbitration Group. So enough about us, on to today's webinar. Shan and I have worked together many times in differing roles over the last few years and have come together today because we're both always being asked about dispute resolution in the region. And with the support of the BVI Arbitration Centre, felt that we could bring together her legal expertise and my technical and practical knowledge to develop this webinar today. So that's probably enough for me for the intro. I'd like to hand over to Shan for the main part of today's presentation. Over to you, Shan.
Thanks, Chris. Finally, I've got the cue correct, so I apologize for not getting it right the first time around. It hasn't been a particularly good day today, I must confess. I woke up this morning and it turns out just 2 streets down from me, they're building a hotel. And so they started the construction works. And I got slightly worried because I thought, oh dear, this means I'm going to be trying to speak while there's noise going on. Thankfully, the noise stopped at 10, and I realized because of the torrential rain, which then proceeds to come up, and that's disconnected our internet. So I'm currently doing the presentation using data. I'm keeping my fingers crossed that it will last for the entire session and we won't have any interruptions. If we do, if you just give us a few minutes to sort those issues out, and hopefully I'll be able to finish. And if not, then we may have to reschedule. But I'm keeping my fingers crossed that it's going to work for the full session. And while these mishaps have created some anxiety for me this morning, I think they actually are fitting when we talk about disputes in construction, because in fact, that's exactly what happens on construction projects. Everyone goes in with the best of intentions, hoping that everything is going to work. And then in fact, the things we fear that are going to cause issues don't, and the things that we didn't give any consideration to do. I did not anticipate that I was going to have to be dealing with internet. I was worried more about construction. Turns out I was focused on the wrong thing. And that's what tends to happen on construction projects. Everyone is focused on specific things and they don't have a holistic picture as to the type of disputes that are likely to rise. Now, I have no doubt that you have probably have participated and watched multiple webinars like this one, both in the Caribbean and internationally, where speakers advocate for one alternative dispute resolution process over another. And there is no doubt that each process has its own benefits and disadvantages. And we're going to be talking about that briefly in our session. But today, what I really want to focus on is looking at dispute resolution less as a process and more as a tool for the construction industry, which they can use to better manage their projects. Chris and I, as he said, have worked on in several capacities together, one as expert and counsel in a dispute, a fairly large construction dispute. And when technical people speak, they want to be practical and get to solutions. But when lawyers talk about ADR, we talk about the part of it that's enjoyable to us, which is the actual process. And I know a lot of technical people aren't particularly interested in the nuts and bolts of arbitration or other ADR processes. So today, what it really is, or its intention, which is as a tool. And then I want to look at specific disputes and then demonstrate the practical value that you can get from using the various ADR when disputes arise. Now, sadly, the nature of construction projects is such that they are more susceptible to disputes, more so than webinars are susceptible to internet outages and loud noises coming from outside. And that's because construction projects take years to complete. They involve layers of contractors and subcontractors and employ sometimes hundreds, if not thousands of workers, depending on the size of the project. And this high level of interaction between people, processes, and materials creates an environment that's ripe for disputes. Now, the Caribbean region presents its own unique set of challenges, such as limited resource base and vulnerability to natural disasters. And let's be honest, when you need to ship the majority of your goods and sometimes your materials from another country together with some of your workers, projects can get expensive fairly quickly. And it means that we in the Caribbean have to be all the more diligent in the management of our projects and disputes that arise, because the consequences can be far more dear to us. We can't leverage over volume. Now, construction involves multidisciplinary teams of people who are involved in the construction process for a multitude of reasons, which often don't always align. And when this occurs, goals are jeopardized, communication becomes strained. That strain seems to always be followed by demands, refusals, other intense strains, then harder positions, and then ultimately loss of money. And the participation of different parties in the project is governed by a contract. And that defines the scope of works and the obligations of the parties and the allocations of risk. And the intention is to indicate to the parties through the contract what everybody's supposed to be doing, and if a risk event does occur, how we manage it. Sadly, ambiguity and errors in these documents can often lead to disputes about what was intended by the parties and who should take responsibility for the consequences. I think everyone in the industry, lawyers included, know that despite our best efforts, you cannot address all of the issues on a construction project, in a construction contract. And add to this the fact that construction projects are usually long-term transactions and include a high degree of uncertainty. And we have the perfect recipe for costly, drawn-out disputes. Now, where a dispute arises, all parties have a constitutional right to access the state court system. And no one can be forced to use any of these ADR and any of the alternative forms of ADR that we're going to be talking about today. Having said so, the nature of construction disputes is such that they are not easily resolved using the court process for a variety of reasons. Understanding construction disputes usually requires some level of technical expertise in order to understand the processes and procedures. Parties who choose to go to court cannot guarantee that the judge who hears their case will be au fait with that field. And this lack of expertise can delay the dispute resolution process, because more expert evidence and detailed submissions are required to get the judge to understand the issues that arise. Court processes are fairly strict, have fairly strict evidential rules, which the parties must comply with when they present their case. And sadly, damage in construction is notoriously difficult and costly. And the courts are generally reluctant to use the formulas or calculations that are traditionally used, such as the Hudson's formula, which in some jurisdictions hasn't been met with favor, hasn't been received very favorably. And so it can be difficult to prove the case, and very often the strict rules aren't particularly attractive to the industry. Trials happen in court, and court proceedings are public. That means that both the documents and the hearings themselves are easily accessible. Much of the information on construction projects can be commercially sensitive, and parties don't feel comfortable, are generally reluctant to have that information out in the public stratosphere. And of course, lastly, but certainly most importantly, is the enforceability of court judgments. As any good lawyer will tell you, a court judgment or decision is only useful if it can be converted into money or the remedy that you have claimed. You don't just want to be right, you want to be right and get paid. And court judgments may be relatively easy to be enforced in the country in which they are issued. But when you try to enforce them in other jurisdictions, it becomes particularly more difficult. And given that a lot of our projects are, particularly the large ones, are based on foreign investment, being able to enforce a decision outside of the jurisdiction can be particularly important. So outside of the court process, and having established that this is not the most ideal way to resolve construction disputes, Dispute resolution, the other forms, can be viewed on a sliding scale and go from those which take the more collaborative approach and give the parties more of an opportunity to control the process, like negotiation and mediation. And during these processes, the parties work together or with a third party neutral to come to a solution that everyone can work with, or at least feel that happy with, that they can be satisfied that they've walked away with something that's beneficial for everyone. Now, they're not obliged to come to an agreement, and either party can walk away from the process at any time. In contrast, ADR processes like adjudication, expert determination, and arbitration are less collaborative in their approach. The parties have the flexibility to choose the procedure and processes which will govern the dispute, but they have no control over the outcome, which is decided by a neutral third party. So now that we have an appreciation for the types of ADR processes, what I want to do is look at some of the types of disputes that we have in the Caribbean and look at how we can use these ADR processes to best resolve them. So most large-scale projects in the Caribbean are either government-sponsored or funded by foreign direct investment. And these projects involve persons' action practice traditions and personality clashes, particularly between employers' representatives and contractors, are not uncommon. Now, if left undressed, disputes relating to persons can have a devastating impact on the success of a project. Failure to engage with each other can engender hard feelings and escalate the situation. When this occurs, contractors may front costs with the fear of getting stuck with large unforeseen costs, and then engineers may feel that the contractor is more focused on drafting claims than progressing the project, or that the delay on the project has been caused by the contractor's poor management. Very often, projects get to dead silence, which leads to mistrust, and delayed response can further cause disruption to the project. Now, disputes involving people are best dealt with. Let me just, sorry. Disputes involving people are best dealt with using the more collaborative approach associated with negotiation and mediation. While standard form contracts make provision for the parties to settle disputes amicably, the requirement is usually triggered after the formal dispute resolution process has already commenced. For example, in clause 20.5 of the FIDIC standard form, parties are required to attempt to negotiate action has been submitted by one of the parties. And at this stage, settlement discussions will be more difficult because the dispute has been ongoing and the parties are likely to have become entrenched in their positions. It was the recognition of this lapse in the standard form contracts which resulted in the creation of the NEC form of contract by the Institute of Civil Engineers in England. And this standard form takes a different approach and is focused on real-time management of the issues that arise on construction projects. And it promotes a collaborative approach to resolving disputes throughout the course of this project. The rigorous management approach can be more costly upfront, but if used strategically, it can avoid the cost and delay associated with disputes, particularly those related to people. Even if the parties opt not to use the NEC forms, there is no reason why they cannot actively seek to negotiate disputes when they first arise. During negotiations, parties can attain a technical understanding of what has happened. They can identify agreed and disputed facts, analyze how costs and schedules were impacted, and discuss why additional funds or time are, and in some instances are not, a fair result. If undertaken early enough, the meeting can even include discussions on mitigating delay and costs and how the project can best move forward. Negotiations offer a forum for meaningful dialogue regarding the event. and its associated claim, and sharpen focus on the dispute if it cannot be resolved. Even if the parties believe they will move on to more formal forms of dispute resolution, it's always a good idea to start with negotiation. And a good tip for getting a good result is to focus on the problem as opposed to the people. Taking an aggressive or accusatory approach to discussions will only further divide the parties. The scope of works is an essential element of the documents as it sets out the design and specifications to which the contractor must complete the works. Despite best efforts, all scope of works is likely to have drafting errors or missing information, which may require variations to the design or construction process. Standard form contracts can provide common ground for contractual definitions, clarifications of construction operations, and specific project requirements. But most of the players in the construction industry already recognize that a perfect set of contract documents just simply doesn't exist. Where the consequences of an error or ambiguity have a significant impact on a project, parties can easily become entrenched in their positions, as no one wants to take the responsibility for a mistake or an ambiguity. In these instances, mediation can work well as it focuses the parties on the problem as opposed to the people involved in the project. While mediation has its place in resolving disputes, it is commonly not made mandatory in construction standard forms. The FIDIC form doesn't include mediation at all. And the JCT form only requires the parties to give serious consideration to using mediation, but again, it is not mandatory. Now, on the face of it, I can appreciate how parties in the construction industry would think or get the impression that mediation is not a good form of dispute resolution for construction disputes. But that's simply not the case. Mediation reduces conflict and costs less when compared to more formal forms of ADR like adjudication and arbitration. Further, an experienced mediator can help the parties evaluate the facts objectively and make recommendations that can quickly resolve the dispute. Moreover, mediation provides a solution which may not even address the actual merits of the claim before the parties themselves. And that means that the parties can really get what they want out of the deal because there's less focus on who's right and who's wrong. Now, for mediation to work, it requires the full cooperation of the other side. Where parties are not committed to the process, it is easy to use it as a stalling tactic. And this is the reason why mediation is normally not mandatory in the standard form contracts for construction. Another issue which arises when using mediation is enforcement of settlement agreements. Like court judgments, settlement agreements in mediation are difficult to enforce because up until recently, there was no convention which facilitated the recognition of these agreements internationally. Thankfully, in 2019, 46 countries signed the Singapore Convention, which facilitates the enforcement of mediation agreements across borders. And as more countries sign the convention, this will improve the enforceability of settlement agreements. And we'll see, hopefully it will encourage more persons to use the process in international contracts and large construction projects. Now, various factors can cause payment disputes to arise on construction projects, and they are by far the most common that one will see, irrespective of the size or value of the project in question. Now, sometimes these disagreements are as a result of an outstanding balance, such as a contractor who has not received payment for the works, or a dispute as to the value of the works under an interim certificate or interim application had been made by the contractor. In the construction industry, cash is king, and the failure to keep funds moving can have a devastating impact on the progression of the project and financial health of the contractor and subcontractor. Now, payment disputes are prevalent in the Caribbean, but this by no means makes us exceptional. Recognizing the impact payment disputes have on the construction industry, the UK passed legislation making adjudication mandatory several years ago. Now, adjudication brings with it several benefits over the other forms of dispute resolution, and it has become the most commonly used method of dispute resolution in construction over the last 2 decades in the UK. Adjudication almost always offers a much quicker resolution, with a decision usually being reached within 28 days. It can also be relatively inexpensive if used properly. Adjudication is not necessarily appropriate for disputes that are complex or multi-issued, but if the parties consent to a longer period of time, it is possible to resolve more complex disputes by adjudication. Now, unfortunately, despite adjudication forming part of both the JCT and FIDIC forms of contract, they are not frequently used in the Caribbean. And I think this can be attributed to the lack of a regulatory framework to facilitate the process and its enforcement. Further, attorneys and construction professionals are not particularly au fait with the process, which means they are less likely to want to use it. The secret to using adjudication effectively is ensuring it is used at a time when the dispute arises, and it is clear that no resolution can be reached using the less formal processes like mediation and negotiation. Very often in the Caribbean, parties will wait until the end of the project to start the adjudication process. And at that time, it's too late for it to be effective as a temporary measure. The purpose of adjudication is to keep the project going. And by way of example, I was named as an adjudicator on a project in an island in the Caribbean. The parties had an issue about whether or not a particular item of works fell within the scope of contract and therefore was to be priced according to the bill of quantities, or was outside of the scope of contracts and therefore gave the contractor the ability to price for it separately. That issue was causing tension between the parties, and had the parties not used adjudication, it would have dragged on, tensions would have escalated, the contractor would have threatened to stop the works, there would have been a lot of tension, and then it becomes a people issue and it escalates, and then you have further disputes. And that issue doesn't get resolved until the end of the project, by which time the parties have moved on, they don't have all the facts ready available to them, they don't have all the witnesses. On this particular project, at the time that the dispute arose, they referred the matter to me. I made a decision within 28 days. While we were going through that decision-making process, the project continued. Once they had their decision, everybody knew where they stood and they could move on with the project. Now, of course, I can appreciate that that can cause some level of difficulty for the parties, particularly when you're not sure if 28 days is a long enough time and you may not have sufficient time to present your case. But remember, because it's temporary, the parties can revisit the issue if they're dissatisfied and have the arbitrator or make a decision or hear the issue again. So you get to relitigate the issue if a party is not satisfied with it. Now, unforeseen conditions are very prevalent for obvious reasons. Weather and soil conditions can wreak havoc on construction projects. And in the Caribbean, as I have proved today, one never knows for certain what the weather will bring. And it's not uncommon to have several years of relatively good weather followed by a string of natural disasters. And certainly, I think BVI can testify to the fact that of the devastation that hurricanes can have in the region. And sadly, they're not the only country who has been affected. And when hurricanes impact the projects, they can cause substantial property damage, material shortage, disruption, and delay. Even if you are fortunate to have good weather, the unpredictability of physical site conditions can necessitate design changes during the project. Where these events arise, the parties should look to the contract, which will explain how these risks are allocated to the parties. So for example, under clause 4.2 of the FIDIC Red Book, a contractor who encounters unforeseeable physical conditions on site is entitled to claim for any delay and costs which arise as a result. Now, having established how a risk is allocated, the question then becomes, and which traditionally causes the dispute, is how do we interpret that? So if you look at FIDIC in terms of unforeseeable, FIDIC defines unforeseeable as events not reasonably foreseeable by an experienced contractor by the date of submission of the tender. So determining if a physical condition was foreseeable is an issue best dealt with by an expert who understands the nuances of construction as opposed to someone with legal acumen, because they're not going to understand, what a contractor is reasonably expected to understand or to know when he enters into a contract. For this reason, these types of disputes are best dealt with by expert determination. In some respect, the standard form contracts do recognize the need for an expert to make a decision when technical issues arise on projects, and most contracts will assign this responsibility to the employer's representative. So for example, under clause 3.5 of FIDIC, the engineer is empowered to evaluate and make determinations of various claims by the parties, such as extension of time claims by the contractor and an extension of the defects notification period by the employer. And when he's making these decisions, he puts on a different hat because he's required to act fairly and impartially, taking into account the arguments made by both parties. The decision of the engineer is binding on the parties unless it is revised by the more formal forms of ADR in the contract. Now, the logic behind this form of dispute resolution makes perfect sense. In theory, the engineer has been intimately involved in the project and therefore has firsthand knowledge of the facts and is best positioned to decide issues that arise between the parties. Having said that, ultimately, he is the employer's representative. As hard as he may try, it's difficult to take off this hat and replace it with an impartial one, particularly when the engineer has been privy to and engaged in discussions with the employer about the project. In this context, under the FIDIC form, the use of expert determination is by no means perfect, but it is mitigated by the fact that the contractor can immediately refer the dispute to the dispute adjudication board or arbitration if the party is dissatisfied with the decision. Now, very often, particularly in the Caribbean, parties will receive a decision from the engineer and they won't take any action under the contract. Instead, they engage in writing letters, objecting to the decision, threatening to stop the works, and taking other sort of more informal courses of action. And while discussion with the engineer is, of course, useful in trying to come to a resolution, ultimately, in the face of a binding decision by an engineer, it's highly advisable to follow the notice provisions in the contract to preserve your position. FIDIC, particularly the more recent version, the second edition, which came out, I believe it was last year, it's very, very strict in the notice provisions, and a contract file or follow the necessary notice provisions in the contract. And I have been involved, and I'm sure Chris can attest to that as well, in several projects where the contractor has a legitimate claim, he just hasn't done what he was supposed to do under the contract, and essentially loses out on a technicality. So there is a balance when using ADR in this process. You want to submit your notices so that you preserve your rights, and then engage in discussions, whether by negotiation or mediation, to try to get the employer to understand and come to a compromise. If that compromise, you're unable to reach that compromise, at least you know that you can come back and use the other forms of ADR under the contract. Extension of time claims are certainly one of the more common issues that arise on construction projects. Given the multitude of factors which can negatively impact a project, it's not uncommon for there to be some type of delay and arguments as to who should be responsible for it. That's almost automatically flows on almost any project. And given the complexity of these arguments, both factually and legally, these types of claims are generally more suited to the more formal processes of ADR like arbitration. Now, just so we're clear, I am not saying that if an extension of time claim comes, the first thing you should do is press the arbitration button. What I do suggest, however, is that once an issue arises, you check the contract to see what it is you're required to do to be able to enforce your right. Ensure that you take those necessary steps, and then you enter into the more informal negotiations or mediation, if that's provided for in your contract, to try to come to an amicable resolution, knowing that if that resolution doesn't arise, you can rely on the more formal processes in the contract. Now, arbitration allows the parties to choose a neutral who has construction expertise, and if a suitable arbitration clause is used, and I emphasize that because in the Caribbean, sadly, very often we don't give consideration to the suitability of the arbitration clause, and that can cause its own set of problems, which I'm going to talk about in a bit. And if the arbitration clause has a procedure which allows both parties to present their case in a fair manner, that allows the neutral to come to a good decision, then generally speaking, arbitration works. Unlike the court process, the parties can ventilate their issues privately. And again, if the parties use the procedure effectively, it can be quick and cost effective. While arbitration presents multiple advantages to the construction industry, the process is very often condemned in the region as a waste of time and money. Parties point to long delays and high costs as some of the reasons why they shy away from using arbitration and will instead try to settle using more informal ADR processes. Again, as I have said before, attempting to settle using negotiation and mediation should always be your first port of call. But sadly, they don't always result in a resolution of the issues in dispute. And where the dispute requires a third-party intervention, arbitration can work, again, if used effectively. Now, sadly, in the Caribbean, there are many factors which prevent the industry from truly benefiting from the use of the process. The standard forms that we use in the region are intended to be used in jurisdictions which have updated arbitration acts. Sadly, many countries in the Caribbean have outdated versions of the act, which do not provide the support system to facilitate the effective use of arbitration. More critically, when standard forms are used, sufficient thought is not put into making the amendments to make it suitable for the project. Parties should always review the ADR clause in the standard form to determine if it's suitable. A classic example of a issue that generally arises in the Caribbean is when we use the JCT form, which is a British contract. Now, its provisions include using adjudication, but it's intended to be used in England where they have domestic legislation that makes adjudication mandatory. Since we don't have statutory adjudication in the Caribbean, these provisions are not necessarily appropriate and need to be amended to reflect the fact that we don't have statutory statutory adjudication in our jurisdictions. Where parties do not pay particular attention to the ADR clauses in their contract, they risk signing on to a process that cannot deliver the value. And it's not the process that doesn't work, which I tend to hear a lot from contractors and employers, but rather that the parties have not used it properly. They don't understand it, they don't know when to use it, and then they end up not getting the value out of it. So I certainly, the purpose of this session was just to demonstrate with real examples how parties can leverage the benefits of ADR and how they can actually use them for specific disputes. Now, having taken a look at the types of disputes and how to use ADR to mitigate the impact delay and disputes can have on projects, I'll now hand over to Chris, who will discuss how to avoid disputes from arising in the first place.
Yeah, thanks, Shan. Give you a chance to catch your breath. Yeah, dispute avoidance. As Shan's touched on in her presentation today, once the projects go wrong, there are many different ways to manage the disputes through the formal channels of mediation, expert determination, adjudication, arbitration, without having to go to litigation whenever there's a dispute. However, I think it's worth going back a few steps in the process to right at the beginning, when the client has a vision of what they want to develop, as often issues which give rise to disputes can be mitigated and managed through best practice measures to avoid the disputes before they even start. As you know, as Shan touched on earlier, construction projects are expensive, long-term, complex transactions with high levels of uncertainty and multiple stakeholders involved. Therefore, it's impossible to resolve every detail and foresee every eventuality at the outset. As a result, situations come up that give rise to conflict. The conflict leads to deterioration of relationships, breakdown in trust, eventual claims, project delays, additional costs, and ultimately breaches of contract. This leads both parties to revert back to the contract and methods of dispute resolution, which Shan touched on earlier today. There are, however, a number of ways which on the surface seem overly simple, but can have a huge impact on how projects run and the overall outcome. This topic in itself could be another webinar, but to try and keep it at a high level, these are clear communication between all parties. At the outset, establish clear lines of verbal and written communications between all the parties involved to avoid any potential misunderstandings. Most disputes occur because of different understandings of the same issue. Add in a good mix of emotion, and then suddenly a minor issue becomes a huge claim. Procurement, good procurement. Project risks can and should be allocated to the best party able to deal with it, as Shan mentioned earlier, ensuring that both parties know exactly what they're getting into. The end result of good procurement is a clear roadmap for the completion of the project through managing cost and time expectations. Regular reporting. Keeping all stakeholders regularly updated on objectives, issues, risks, costs, progress, and quality at each stage of the works, and also proactively dealing with issues as and when they arise, and not ignoring them and hoping they'll go away. Good record keeping. Now, Shan touched on this earlier as well. Timely notice of events, good record keeping. Conflict can often be avoided by keeping proper and detailed records of agreements, instructions, drawings, variations, labour, and as we found out today, weather conditions as well. Good payment practice for cash flow purposes. Establishing and adhering to good payment practices, closely monitoring and controlling the contractor's cash flow and vendor payments helps keep the works progressing on site and materials arriving in a timely manner. Party management, or what do I mean by that? Good project management, good client management, design team management, contractor management, and third-party management. Now, good understanding of the client's brief and objectives is a simple way to prevent future conflict. And of course, making sure you get it in writing. Closer cooperation between the project stakeholders can improve overall teamwork and the flow of information, and ensuring the provision of fully coordinated design information with clear instructions and directives from the design team as the project progresses. And lastly, good contract documents. Well-drafted, clear contract documents, which include for the appropriate dispute resolution procedures touched on earlier, of course, naturally referencing the BVI IAC model clause, brings us back full circle to the different types of dispute resolution Shan was discussing earlier. So that's it from me today. I noticed that there are a number of questions starting to come in, so I will try to address them. Shan, it says a question from Nigel. What are your thoughts on the allocation of risk and opportunistic behavior as to the causes of disputes in the Caribbean?
Yeah, thank you, Nigel, for that question. And I think it's one that isn't unique to the Caribbean, but hits us particularly harder because of the unique issues we have when we're small islands. In bigger countries, contractors can leverage volume. Unfortunately, we don't have that ability to do that when you're working in a small island, even if you choose to work within the region, which several large construction companies do. The cost of doing that business that way is a lot higher. This means that contractors are under more pressure to win projects. Now, certainly from my experience, and Chris can share his experience as well, I find that when contractors are bidding, they hyper-focus on price, but they fail to look at all as to what the contract documents say. And the employer, given the old adage, he who has the gold makes the rules, will draft the contract to suit his objectives. Now, when I first started practicing in construction, I was very excited to redraft contracts and tell people what they should and shouldn't put in it. But the reality is there are some commercial practicalities that contractors have to face when they put bids in. So yes, I think that there is opportunistic behavior in the sense that because the employers have the power, they tend to be more militant and redraft contracts to suit their own objectives. But my advice to contractors is when you're going into the project, it's not a matter of avoiding all the risk, it's a matter of understanding what those risks are and putting measures in place so you know when you put in your bid what the chances are, where the pitfalls lie. And very often that tends to be ignored by contractors. They don't look at the contract, and then it's only when an issue arises, they go and see, oh shucks, they've removed the unforeseeable provision, so I am responsible for all physical site conditions that are on the site. Very quickly, the project becomes a lot more expensive. Now, a contractor may decide, look, I need this job, so I'm going to take the risk with this clause out, but you should be going into at least knowing that that's a risk that you're taking. So that way you can have some sort of measures in place if that issue does arise.
Yeah, it comes back down to good procurement. If you have good tender documents at the beginning, you're managing everyone's expectations from the start. We have another question that's just come in. Thank you, Martin. With supply chain issues due to the pandemic and delay and cost implications, is any relief available under force majeure? It was not in earlier with oil embargo issues.
Yeah, I think it depends. Sorry, did you want to take this?
No, you can go for it.
No, I think force majeure has become, the topic of the day, not just in construction, but across all of the other industries as well. And it really depends on the contract that you're looking at. I think under the FIDIC form, the force majeure clause has several provisions that it's arguable whether or not you can fit the pandemic in there. I believe that there is scope to argue the pandemic because it does make provision for issues that could not have been reasonably foreseeable by the contractor. And let's be honest, a pandemic is not something which was reasonably foreseeable by anyone. But again, it's going to come down to a legal argument, and we're going to see these cases coming over the next few years. And it's only when the decisions rise that we're really going to know one way or the other. It's also fairly project specific. So it will depend on how the pandemic has affected your project and whether or not it's arguable that it has caused delay and the ways that it has.
Yeah. There was another question that's just come in about BVI arbitration and the Arbitration Centre and the BVI IAC model clause, which I touched on earlier. I think there's actually a really good short synopsis that the Honourable Barry Leon had prepared in conjunction with the BVI Arbitration Group. So what I will try to do is, for everyone who's on the call today, I will send that out to everybody to make sure they've got a copy of it, which just touches on the advantages of BVI arbitration. I could go into it today, but it would probably take us long past our time.
Yeah, I mean, certainly the BVI model clause is a good provision. I think if you're going to include it into a standard form, you have to be careful to ensure that it sits well with the existing provisions. So sometimes people tend to just pull out and throw in, and you don't want to do that because the contract has been drafted with that in mind. So for example, if you're going to do it with FIDIC, FIDIC has a DAB. So you want to ensure that whatever you slot in fits well with the DAB provision. And that just takes a little time to go through. But certainly it is a good clause, and I would recommend using it.
Yep, so I'll get that out to everyone who's attended today. There was only one other question which touched on adjudication. You know, you said it's extensively used in the UK, not much used here, but I think you covered that really within your presentation already. And that is what all I can see for the questions today. I don't know if, Shan, if you had anything further to add. I say we're trying to wrap it up within an hour. We've got about 7 minutes left. I think we're okay.
Yeah, no, I think generally the idea of this webinar was just to provide some sort of high-level understanding of practically how these various ADR provisions can be used. I think, as Christopher mentioned, there is scope for us to do other webinars on particular issues. I know one that everyone wants to is interested in is how do you use adjudication when there is no regulatory framework, and I think there's probably some merit in dealing with that. And also the DAB, and how do you cost effectively use the DAB, because I know that's a concern that a lot of people in the region have, particularly since the pandemic. There are a lot of payment disputes. So certainly that's something that we can look at doing in the future. But I want to thank everyone for attending. And I want to thank my data for not letting me down. So I can now take a relief. So thank you everyone for your patience.
No, thank you very much. Yeah, as you say, there's probably half a dozen topics that we've covered today, and really we've only just skirted across the top of them. So yeah, so if anyone does have any ideas of anything further, Shan and I would be happy to put something else on. You know, keep it short and sweet. You know, keep it under an hour so it doesn't take up too much of your day. Actually, see, there's another question just coming in from Nigel. He says the areas you listed are how to avoid the dispute, but these need to be done before the dispute occurs. Yeah. So it's just part of good practice. It's part of when you're getting engaged in a project to make sure that you go through all the lists we went through before, you know, the good record keeping, the making sure you've a written client brief, the amount of times you don't really know what the client wants from the beginning. Going out to tender on sets of drawings that aren't complete or are only 50% complete, but yet your contract talks to it being 100% complete and fully scoped out. And those differences, and you're not making allowance, you're not making contingency in there for any changes. You know, yes, you can tender a project with a sketch on the back of a napkin, and you can also tender it on full set of drawings, but you've got to understand and explain to the client that there's a big risk and a difference between the two. It can be done. I mean, you wouldn't necessarily want to do it, but you have to be able to adapt and work your contract and just understand what you're getting into at the outset, such that you don't end up with these disputes towards the end. And I think that's it. Shan, if you don't have anything else, I think we will close out for today. Thank you everyone else for attending. And as I say, let us know, reach out to either of us and we'll see if we can put on some further webinars in the future for you.
Thank you very much, everyone.
Thank you very much for today. Thank you. Bye-bye.